1. This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hebner. And on behalf of Judge McBrayer and Judge McGee, we welcome counsel to this oral argument, which we are live streaming in order to fulfill our obligation to maintain open courts. We will conduct the hearing in the same manner as if we were in the courtroom together. Each of you has 15 minutes to present your arguments, and the appellate has the right to and has reserved some of that time for rebuttal. There being announcements, I will ask Mr. Hebner to call the case.
Tony Allen Baker versus Shauna Phillips McSherry.
All right, Mr. Weston, you have the floor.
Good afternoon and greetings from the Upper Cumberland. I'm Michael Weston. I represent the appellant mother, Miss Shauna McSherry. And this is a parentage case that was filed by the father. We had a trial on October 30th of 2020. We raised 5 issues on our appeal, the most important being obviously regarding the child. The trial court erroneously adopted a plan that is not in the best interest of the child and is not supported by the evidence.
Mr. Weston, one of the issues that you raised that I'd like to start with first is the sufficiency of the court's orders here. I mean, you seem to have the agreement of the appellees here that there's not a whole lot of analysis of the best interest factors in this case. You've asked us to soldier on to try to make our own independent factual findings, but I'm a little concerned about how we can accomplish that in a case like this. Could you address that issue first, please?
Yes, sir. So, and yes, I understand a lot of times kind of the default, if you will, is for you all to remand it back. We are asking here that the court not do that for a few reasons. One is just that it's already the way that the schedule that was granted is kind of a black cloud over my client. There's really not a sense of finality here because we know this schedule isn't going to work here in just a few years. And, so we're just sitting here, okay, just wondering, okay, what's going to happen? Obviously you all are well aware that you clearly have the authority to soldier on and do that. I would say in this case, there was plenty of testimony, plenty of exhibits entered that the record is developed enough for this court to make that determination. And it's also not so huge.
Isn't there there's some differing perspectives here. And how are we supposed to tell which one the court necessarily adopted here? I guess we could assume that the court, you're asking us to assume that the court credited the father's testimony about the conditions of his mother's home and the bug bite situation and other things like that?
I think even if you take that out of it, just the undisputed proof that that my client was the primary caretaker, that she's the one that always took the children to the doctor. I think there's enough there without getting into those determinations that you're talking about to still make a proper ruling.
That actually sounds like though you're asking me to ignore would you ask the court to ignore some of the proof though? Clearly the court did something with that in coming up with its termination to rule for father here. So, I'm still worried about how we would soldier on in a case like this.
Okay. Well, the ruling by the court was an equal schedule with my client being the primary parent. But I understand your concern, and I don't know that I can alleviate that concern fully.
Okay.
But I feel like the record is developed enough that the court can go through and would be able to make the determination that supports our position, even taking all of it together as a whole.
Sure. Thank you, counsel.
So, as I was saying, the court did order equal time here, and the problem with that is that the parents are 92 miles apart. So right out of the gate, we know it's going to be unworkable. The child's going to start school in the next few years, and then we have a problem on our hands, which I contend goes directly against 366404A, which talks about some of the requirements a parenting plan is supposed to have. A1 specifically says that parenting plan is supposed to provide for the child's changing needs as the child grows and matures in a way that minimizes the need for further modifications of the parenting plan. So we're already set up where we know we're going to have a problem here in just a few years. And then also, of course, 366106A, our best interest factors. But before it goes into those, specifically says the court's supposed to consider the locations of the residences. And if you look at some other comparable cases over the past few years, we have Dillon versus Dillon, 100 miles apart. One parent got 283, one got 82 days. Strickland versus Strickland, 50 miles, 245 days to 120. Hughes versus Hughes was 60 miles, 265, 100. Richards versus Richards, 50 miles apart, 265, 100. And the proposed plan that my client proposed at trial was a 265, 100, which, given the distance between the homes and those factors, is what we would contend still in the best interest. And then, of course, Judge McBrayer, as you already stole my thunder there, we do have the findings of fact and conclusions of law issue. And I understand the court's concerns there. But like I said, I do think the record is developed enough for the court to soldier on in this case, but also not to where you're going to have to soldier on with thousands of pages. We've got a good transcript, and we've got some exhibits and a good record, but it's not a voluminous record as well. And I will point out also, maybe a month or so ago, NRA Trinity P, I think might have been Judge Clement that authored that, but it was a grandparent visitation case. But as we know, kind of the gatekeeper, if you will, factor was their opposition to that grandparent visitation. And in that case, the court did not make a specific finding, and this court did soldier on and go ahead and review the record de novo and make that determination on its own. So that's what we would ask on that. And we would contend the parenting plan that was adopted is not in the child's best interest. The other not as important factor, but it's still important, if you will, was the trial court setting aside the final order and then changing the child support amounts and then the tax, who claimed the taxes. So, of course, the child support guidelines already speak to, in the calculations, it's already assuming that the person receiving child support is the one claiming the children, and it adjusts those calculations accordingly. So the father in that situation who's paying the child support, he's already getting credit for not receiving the tax credit, if you will. So the original order the judge signed, my client claimed the child on the taxes every year, and then opposing counsel asked to set aside that order, and the judge did change that to alternating. When it was set aside, though, there was really, the only thing I ever got was that I was wrong. I never did get this is why it's wrong, this is what it should be type thing. And the contention was the taxes and then the amount of retroactive support. Don't think it was properly raised. Obviously, we discussed it in the brief. I don't think any sufficient grounds to alter or amend were alleged there. But we would contend that it should be the original order on that as well. And that's all I've got at this time, unless there's any questions from anybody.
Hearing no questions, we'll hear back from you on rebuttal. In the meantime, we'll hear from Ms. Morgan.
Thank you.
Yes, Your Honor. Cindy Morgan with the White County Bar. Your Honor, I think that the questions that you've asked are very relevant. I think it touches to the heart of this matter. And of course, in my brief, I argued that there was very little findings of facts and conclusions of law presented by Judge Benefiel. I think the only things that he cited was that the mother had been the primary custodian, and about a parenting class, of course, had not been ordered, but she had already taken the parenting class. And the problem with this, Your Honors, is that the trial court's given a lot of discretion with regard to the best interest of the children. They're given wide latitude. And the reason the court says they're given that wide latitude is because they're able to firsthand see the people, to witness the demeanor, and to witness and to assess their testimony, not just pigeonhole a set of facts. And I think that what is being asked of you today is for you to just pigeonhole and make a determination, not necessarily what Judge Benefiel found is relevant. We don't take and score and say, okay, the factor 1 that's going to rate 2 points, or factor 2 is going to rate 3 points. We don't do that because each child is an individual. Each child deserves individual attention as to their circumstances and their situation, as each parent. Their facts and circumstances are all different. And so we don't just look and pigeonhole these and say we're going to assign a score. And so Judge Benenfield, in doing what he did, looked over and assessed the overall interest of this child. Now, how he did that and what factors he considered the most important is what's missing in here. I think it's difficult. I'll be honest. I think it's difficult for the court to determine whether or not he properly considered each one of these factors. It's obviously he considered the factors, but I don't.
Now, you say that's obvious, but how do I know that? I mean, because the orders don't have a reference either to the statute or to the factors individually. So,
and I think that's the issue. But now, Judge Benenfield did say that the deciding factors for 2 issues, and he talked about. Okay. And so
that was part of his oral ruling.
Yes, that was part of his oral ruling that he considered, and the 2 factors that most impressed him or made him lead to one side, and that was just appointing the primary residential parent. He leaned towards equality with regard to the time the child should be spending with each parent. He leaned towards equality on that, but as far as designating a primary residential parent, he cited 2 factors in making that designation. And I think that under the circumstances, as the court says that there's not enough evidence here with regard to what he considered, I think it would be appropriate to remand that so that he could make a findings of facts and conclusions of law, rather than asking the court to take and assume that he placed more emphasis on one factor than the other. I mean, in our argument, we argued that he didn't place enough emphasis on the mother's attempt to try to keep the child away from the father, her interference with the child's relationship with the father at the beginning. At this point, we don't know how that factored into the court's decision because the court didn't make that finding. And so it's our position that if anything needs to be done, it's going to be remanded to the court so that there is a findings of fact, conclusions of law that's consistent with what the court's direction is, so that we would know what emphasis is placed. I don't think that you could just take and say, well, based upon this proof, we can make that decision. I think that would be taking away the discretion and the latitude that's given to the trial court in making those decisions.
Ms. Morgan, the trial court loses the benefit of the abuse of the discretion standard, loses the benefit of the deference when it fails to make findings of fact under Gooding v. Gooding and Loveless. So we don't defer to the judge's decision when the judge doesn't make findings of fact.
And I understand that, but in a custody case, it would be difficult then to take and without witnessing firsthand the person's demeanor or to consider what factors, how there's no way for the court to determine which one of these factors should be weighed more heavily or who's telling the truth. And in this case, there was various testimony. There was testimony about, like you said, about the bug bites. There was testimony about whether or not their grandmother's home was fit, or there's testimony from my client's standpoint that he felt like the mother interfered with his visitation. From her standpoint, she did more than enough to encourage him for visitation. So it would be difficult to assess the credibility, and how would the court then go in here based upon just reading a transcript and determine who's telling the truth and how they should weigh those factors. And I think that's the difficulty.
Did the court when the court made its order, and did it incorporate that ruling by reference into its order, either order?
No, actually, there was the order was prepared by Mr. Weston, and I don't think there was any reference to the oral findings of the court at all.
All right.
And which brings us to the setting aside of the order. I think that in Mr. Weston's brief, he talks about a Rule 60 motion as opposed to a Rule 59 motion. And that order went down. My recollection was November 17th. At that point, I had been in ICU with COVID for about 8 days just prior to that, was out of the office for about a month after that. When I found out the order had been lodged with the court while I was in ICU, then when I was able, we filed a motion to set aside or alter or amend that motion. That was filed within the 30 days before that order was final. A Rule 60 motion would be for a final order. A Rule 59 motion, of course, would be for an order that's not gone final. And a Rule 59 motion, Rule 59 would allow the court in his discretion, without even having a motion, to alter or amend any findings because it's not final at that point. We had argument, I think it was on December 7th, before the order even went final. The December 17th would have been the day the order went final. We had argument on December 7th. The court did alter that order and did change the ruling with regard to the child support as well as the taxes. As a matter of fact, I think when the notice of appeal was done, there still was an order down with regard to the issue with regard to the back child support. We negotiated that and got an order down while the case was, after the case was already appealed and before the Court of Appeals, we got an order down on the child support amount for the court. So I think the only argument he has is that we shouldn't have altered or amended, not that the amendment was wrong and not that there should have been a different figure, that just the court should not have altered or amended. And I've not heard anything that it was wrong for them, that the calculations were wrong or anything. Those were actually calculated by myself and Mr. Weston. And in fact, in the trial court didn't make the calculations as to how much the back child support should be. They left it to us to calculate those numbers, and that's what we did. So, and that would end my argument, Your Honors.
All right. Hearing no questions from the panel, thank you, Ms. Morgan. And Mr. Weston, your rebuttal.
Yes, Your Honor. So first, again, I'll just briefly read her. I do think there's enough in the record for this court, and I have full confidence and faith that this court's qualified enough to review the record and make those determinations as they've done many times in the past. But briefly on the setting aside, it sounded more like a 60 motion, just the text of it. It never referenced a rule at all, just asked to set aside. And again, instead of even stating what the error was or why it should be changed, it was just the fact this is wrong, and never this is wrong and here's why and this is what it should be. I would have to agree that, and it's in the reply brief, that it would be maybe more under a 59 because it's not a final order, and the court could also do it themselves, but you still have to have a reason. You can't just do it. And we've all seen the past, a judge might sit on something a while and send out a letter. Okay, well, after further thinking about this, I'm going to change this, this, and this, and here's why. But it's never, we're just going to change it. And that's really what happened. There was never any contention of what the amounts should be changed to. It was just that my number was wrong. That was in the final order. And it's pretty well settled on a 5904 alter or amend when you would be allowed to do that. I don't think it meets any of those criteria. There was no change in control in law. There was no previous evidence that became available. No clear error to prevent injustice that I see. And as far as the final amount, that wasn't agreed upon. Actually, I lodged a few times my calculations, attached my calculations, and each time opposing counsel will send a letter to the court just saying they objected to it and never provide any proffering of what they thought it would be. So finally, because this court has sent down an order, hey, we've got to get a final order down, I just submitted it and left a blank in there and said, fill out whatever amount you want to put. I need a final order, and the court just put an amount. I have no idea how they came to that amount, but that's how that happened. Obviously, I think that's clear error, but the most important error is the interest of the child, obviously, and the parenting schedule. So that's what's more important to my client. But I think when you take all these as a whole, we've got a kind of a snowball of errors, and they all point to it needs to be reversed. My concern, if we remand for findings, is that we're just going to be right back here in a few months, and we're going to be doing this again. So we would ask that this court make that review themselves. And that's all I've got. If anybody's got any questions, I'll gladly answer.
All right. Thank you, Mr. Weston and Ms. Morgan, for your arguments. We will take this matter under advisement. Mr. Hibner.
Honorable court is now adjourned.
Thank you. And counsel, you're free to